Good afternoon and welcome to our webcast today, The Cannabis Effect, How Evolving State Laws Are Impacting Employment Policy and the Workplace. I am Lisa Messner. I am a partner and our practice head over our litigation practice here at McMurray Schuster, and I'm joined by my colleague, Chad Blackham, to talk to you today about some of the evolving laws within the cannabis space and how those laws impact employment laws and employment policies generally. And so prior to our presentation, just a few housekeeping matters. Of course, we are attorneys, so we would be remiss if we did not have a disclaimer for everyone. And so just be aware that the materials that we are presenting to you today are provided for informational purposes only. You should not construe them as legal advice to your specific circumstance. And any transmission of the information that we convey today is not intended to create or constitute an attorney-client relationship. Just remember that every situation is different and you should not act or rely on any of the information within this presentation without first seeking the advice of an attorney based on your individual circumstances. And then just a couple more housekeeping matters, and I will turn it over to Chad. But today we will not be able to take your questions live during the presentation. However, if you do have any questions as we're making our presentation today, please put them into the chat and we will be happy to follow up with you later to provide you additional information in response to your questions. And then a recording of this webcast will also be available on our firm's website within about a day or so. And so if you know of anyone else who might benefit from viewing this, please pass on to them. The recording will be available on our website at no charge. And with that being said, I'd say let's just get right to it.
Thank you very much, Lisa. Hello, everyone, and welcome. So let's start with medical marijuana generally. So what is medical marijuana? Well, medical marijuana is marijuana. You'll also hear me using the terminology of cannabis interchangeably throughout this presentation. Cannabis is kind of the colloquially referred to proper nomenclature for the marijuana plant. So what exactly is it? Well, first of all, it's a plant with several components. It has leaves, flowers, stems, stalks, as well as hundreds of cannabinoids, which you see that bullet point at the bottom. We'll get there shortly. But the piece that most of you are likely familiar with is the flower. And going into the forms of administration here, how do individuals use medical marijuana? The most common way to use it is known as smoking. Interestingly enough, however, many states, including Ohio and up until recently Florida, actually prohibited smoking marijuana. So the other forms of administration that you'll see are vaping through vaporizers, oils, tinctures, lotions, edibles, things of that nature. So the difference between adult use and medical. Adult use is another term for recreational. Medical marijuana will generally be higher THC value. THC, going into the cannabinoids here, stands for tetrahydrocannabinol and is the cannabinoid responsible for the psychoactive effects of the marijuana plant. In contrast to THC, we have CBD, which does not have the psychoactive effects and is thought to have some ameliorative anti-inflammatory properties. We'll talk a little bit more about CBD and the distinction between it and THC later. So here for you, we have a handy-dandy statewide map demonstrating where marijuana is legal in limited fashion with the light gray, medicinal with the light green, and adult use or recreational with the dark green. As you'll see, the majority of states have some marijuana laws on the books, which highlights the importance of talking about this issue. It's only going to be increasing. So getting into the meat of the presentation, one of the things as an employer or as an employee you might be most concerned or interested in is what are your rights and abilities as an employer vis-a-vis the protections and benefits of your employees under these state medical marijuana regimes. Well, cannabis in all forms is federally legal except for CBD, which we'll talk about later. But that being the case, we deal with an ad hoc piecemeal state by state analysis when it comes to medical marijuana. In particular, every state is going to be drastically different. So the starting point is always going to be your state statutory law. Now, notwithstanding that issue, we can break it into three broad categories as we've demonstrated here. So we're going to, and you'll see we have three states as well: Ohio, Pennsylvania, and Illinois, which are also geographically close together, which I didn't intend, but it's a neat little flourish. So we're going to start off with the pro-employer states, like Ohio. So pro-employer states have great discretion for employers to make what I refer to as employment decisions. And when I say employment decisions in the context of this presentation, that refers to a particular action taken by the employer with regards to the employee's job role. So not something like an infraction, but rather hiring, firing, promoting, demoting, pay raise, pay decrease, tenuring, removing from tenure, or a horizontal, vertical, or lateral job transition. So states like Ohio, very broad protections. You as an employer have the ability to make these decisions solely on the basis of cannabis use. Additionally, you have great freedom in creating employment policies, and dischargement for cannabis use is just cause discharge. In contrast, we have states like Illinois. States like Illinois are heavily pro-employee and limit your drug testing ability, except for some exemptions for federal and regulatory requirements, depending on the law. But in Illinois, employees are effectively treated as a protected class, similar to race, gender, age, national origin, or ethnicity, or as someone with a qualifying disability under the American with Disabilities Act. Then in the middle, we have mixed states like Pennsylvania, which are contradictory. So Pennsylvania actually is very unique. In one breath in the bill, it says you don't have to accommodate medical cannabis usage. And then right after that, it says you may not discriminate against medical cannabis usage. That's a very tough needle to thread, but it is what it is. So we turn to the courts. In Pennsylvania, we have a case here, Palmater v. Commonwealth Health Systems, Inc. And what happened was Palmater was fired from his job for medical cannabis usage and sued the employer. Now, interestingly, Pennsylvania does not have what is referred to as a private right of action. A private right of action is effectively your ability to sue under a law for your own benefit, as opposed to, say, an attorney general enforcement action or something of that nature. It's basically the ability of a private citizen to use a private law for their own benefit. In the absence of a private right of action, generally you are not able to sue under a law. Similarly, in the Pennsylvania case, you would think that marijuana and cannabis are federally illegal. The bill did not provide the right. The employee is unfortunately out of luck. Well, interestingly, what happened here is the court discovered, and I mean discovered, what is referred to as an implied right of private action. Now, what happened here is the court looked to various factors, such as the purpose of the Pennsylvania Act, the intent, and the legislative history, which is effectively the discussions and the studies the legislature look at before implementing a law. The court looked to all these factors and said, well, in order to really affect the purpose of this Pennsylvania law, in order to really get at what we think the legislature was trying to get at here, it only makes sense that this law has a right of private action read into it, even if it's not in the text of the bill. So, interestingly enough, the court read into it a right of private action, even though it was not listed in the text of the bill, and permitted the employee to sue the employer for what was effectively a discrimination or harassment claim on the basis of medical cannabis usage. So zooming out, we have pro-employer like Ohio, very strong statutory protections for employment decisions. States like Illinois, very strong employee protections, effectively treating employees as a protected class. And then mixed states like Pennsylvania, which are kind of ambiguous or might be silent as to the issue, such as states like Hawaii, for instance. And we generally have to look to the courts. Now, what's important here, though, is even in pro-employer states like Ohio, there are some things to be concerned about. So we have in the law what are referred to as theories of equity. Theories of equity effectively exist for situations where there's no specific law on the books, but it only makes sense that one person is able to sue another to get money damages. Say, for instance, I own a company out in California and Lisa lives in New York. Say I tell Lisa, come out west, please just drop your job, drop everything you have, sell your house, move out west. I'll give you a brand new job. It's going to be fantastic, I promise. We talked for months about it, and then, Lisa comes on out to California, knocks on my door. Hi, hello, I'm here for my job. And I say, oh, I was joking about that. Sorry. It was just a big joke. Now, unfortunately, there's no law that says Chad induced me to move out west for a job that doesn't exist, and I sold my house, and now I want to sue him. So we have what are called theories of equity, and the ones we're concerned about here are promissory estoppel and or detrimental reliance. And let's say and or, because these are largely two interchangeable legal theories with different names depending on where you are. So we have a promise or guarantee that is relied upon, where the reliance is foreseeable and damages result as the elements of this claim. In the hypothetical I just gave, I made a promise or guarantee to Lisa that she would have a new job if she moved. She relied upon it by doing so. The reliance was foreseeable because we talked about it, and the damages were suffered insofar as Lisa had to sell her house, move, drop her former job, etc. So where does this pop up in the context of medical cannabis law? Well, where you're typically going to see this is a situation where an employer has a stated policy of accommodation towards medical cannabis. And this can be oral/verbal, or it could be written down. So say you have an employer who tells an employee, yes, I am fine with accommodating medical cannabis, and there are good reasons to do so that we'll get to later as well. But say they tell the employees they'll accommodate cannabis, and then maybe a week later something say, oh, I was joking about that. I'm really sorry. I actually decided that I don't want to accommodate this. So unfortunately, I'm going to have to fire you now. That would be pretty unfair. So if you look at the elements here, there's the promise or the guarantee that the employer relies upon. It's foreseeable insofar as it is their employer telling them, and they are damaged by the loss of their job. Now, if you're listening carefully, you'll say, well, hey, what about a state like Ohio where I have these very strong employer protections? I mean, they're statutory, they're written into the law. How does that impact here? What's important to note is that theories of equity are totally separate, totally different from normal theories of law. So, hey, you might be right. That statutory provision in the Ohio law might be a really good defense against a claim in equity here. But by that point, you're already in court, you're already past the motion to dismiss type stage, and you're already expending the time, money, and resources you don't want to. So these theories of equity, they're applicable in all 50 states. They are applicable regardless of the field of law or the industry you're in. Something to be aware of.
If I can just add one thing.
Please.
One thing to this point, and this is a great point that Chad is mentioning about these theories of equity, and particularly if you take a look at that Pennsylvania case, I think that that most legal analysts could agree that it opens the door for these theories of equity to even expand, broader than this context. And so by way of example, many states have laws that give some kind of statutory right to pursue a legal claim based on an employment decision, but they might be restricted in some fashion. So by way of example, in Ohio, retaliatory discharge based on filing a workers' compensation claim is not allowed by or it is allowed by statute, but it's limited. There's not a jury trial right. There's a very tight statute of limitations. But there's been theories expounded beyond that when there's this statutory right or some kind of quasi-statutory right, like you see in Pennsylvania, that it becomes even beyond a theory of equity that can go into some kind of adverse employment action based on a violation of public policy. And I think that the Pennsylvania case is a very elucidating development, right? That we could see this in these many states where they have the employer type of statutes, that there could be an expansion upon that type of theory.
And Lisa, you bring up a great point about that Pennsylvania case. What's really so interesting about it too, it's kind of twofold. One, I'm surprised they found a implied right of private action, because if the legislature wants to put something like that into a law, they generally will. Second, I'm surprised they found it with regards to cannabis, given the fact that it's federally illegal. So that just goes to show, as Lisa was demonstrating, this is a brand new field of law. It is constantly evolving and expanding, and you really don't know what you're going to get, even if you think the state law is on point. So now we have the Controlled Substance Act and the Drug-Free Workplace Act. I am sure a lot of you listening are familiar with these, and if there's something to take away from this presentation, the interaction of these laws with your workplace is one of the things to take away. So first off, the CSA, the Controlled Substance Act, establishes federal U.S. drug policy and regulates certain substances. The way it does so is on a scale of Schedule 1 through 5, 1 being the most dangerous and 5 being the least. Marijuana and cannabis right now exists as a Schedule 1 substance, meaning it has a quote-unquote high potential for addiction and no currently accepted medical usage. Now, I know that sounds a little odd that we're talking about medical marijuana in the employment context, yet the federal government says that marijuana has no medical usage. These are just disparate laws. These are two opposing viewpoints we're going to have to keep in mind. It's a consequence of the relic of the CSA in the slow moving of the federal government. It's just something we're going to have to keep in mind for the time being. However, what that means is cannabis and marijuana are federally illegal. The Drug-Free Workplace Act, the DFWPA, requires certain employers to maintain a zero-tolerance drug policy. In particular, it applies to those who receive grants or loans from the federal government or contract with the federal government. Now, I know what you're thinking. You know, a lot of businesses contract with the federal government. A lot of businesses receive loans or grants. How do I square this circle? How do I thread, this needle? This seems a little difficult. Well, the conscientious listeners and readers amongst you will note it says it requires you to maintain a zero tolerance drug policy. The DFWPA technically does not require drug testing, and if it did, it technically does not require you to drug test for marijuana, or more specifically THC, the cannabinoid that will pop up on a positive marijuana drug test. If you think I'm being a little too cute with this, a great example is Amazon. Now, I haven't looked at Amazon's books, but I can almost guarantee you they contract with the federal government in some capacity and therefore are subject to the DFWPA. Amazon recently has announced that it will stop drug testing employees for THC, and in fact will call back applicants denied from potential job openings on that basis, given the changing state laws on cannabis. So Amazon also recently announced it's going to start lobbying the federal government for legalization. And, three guesses to why. I'm sure Amazon wants to sell marijuana on its e-commerce platform. But this just really goes to show how one of the biggest employers, and arguably the biggest e-commerce employer, except maybe Alibaba or something, is adhering to the DFWPA, Drug-Free Workplace Act, but nonetheless not drug testing its employees for THC in cannabis. We're going to get into the drug testing specifics very, very shortly.
One question for you, Chad, in this space before we get into the ADA discussion a little bit. What are the legal analysts and scholars saying about any kind of timetable, particularly with kind of the change in administration and things, for the federal government to catch up to the states in this space? Because it seems like, just based on your commentary, and I know that you deal with this subject matter much more than I do, but it seems like they're way behind. And the states are looking for a way to, kind of make up some ground to gain traction on it. And I'm just curious to know, kind of what you're hearing from analysts, what your clients are indicating.
Lisa, you touched on an incredibly interesting topic here. And really, the federal government has effectively had a stance of non-intervention with regards to state-compliant cannabis regimes ever since the tail end of around 2008 during Obama. Now, just because there's a policy of non-intervention doesn't mean there haven't been some movements. There have been plenty of bills going through, such as the Safe Banking Act, which would allow cannabis institutions to use FDIC-insured banks, or the MORE Act, which would actually deschedule cannabis and kind of reformat the sentencing guidelines at the federal level. Now, that being the case, saying that the federal government is behind the states is a very apt description, and the federal government has certainly been taking their time. Chuck Schumer has actually expressed, along with Nancy Pelosi, have both expressed some interest in passing marijuana legalization within the next couple of years. Will it happen? I'm a little iffy on it. It would definitely be a big policy win for the current administration, and there have been some expressed aims that they would like to do so. But given the confluence of other factors, the divided nature of the federal government at the moment, I think we are unlikely to see any major movement. So like you said, Lisa, we're really going to be looking to the states here going forward, at least for the next 2 years. About 3 years out, we might be looking at federal legalization in some form or fashion. But even when that happens under the doctrine of federalism, I can almost guarantee you, I'm bringing you tomorrow's news today, I can almost guarantee you that the federal government is going to lead the states to what they're doing, and they are not going to touch any of the existing state regimes, even if they do legalize at the federal level. So speaking of the federal level, let's talk about the Federal Americans with Disabilities Act. This again is a law that you are no doubt extremely familiar with. As you are potentially aware, it prohibits discrimination on the basis of disability and requires you to provide reasonable accommodations to employees with disabilities. Now, is medical marijuana covered by the ADA? No, it is not. Medical marijuana and marijuana in all forms and capacities is illegal at the federal level. However, and there's always a however, while medical, and this is another key takeaway, if you only take away 1 or 2 things from this presentation, this is one of them. While medical marijuana is not covered by the ADA, the underlying health condition making the individual eligible for the cannabis or the marijuana likely is covered by the ADA. So what that means is when you fire an employee for their marijuana use, it starts to look a whole lot like you're firing them for the autoimmune disorder or the cancer underlying that marijuana usage. Now, how do we get around this? How do you deal with employees and treat them when they're medical marijuana users? Well, the same way you would with anyone with a qualifying disability. You follow your policies and procedures. You engage in proper record keeping and substantiation, which is just an evidence-based approach to your record keeping, and you engage in your escalation procedures. So medical marijuana, the ADA, it is not covered, and we have a case here, Emerald Steel Fabricators v. Boley, which reiterated this and said that medical cannabis is not covered by the ADA. But this case does opine and touch on the notion that while it does not squarely have a holding on the issue, it does kind of get to what I was saying, that the underlying health condition might be covered by the ADA, and a claim might be able to be brought separately under that. So that's something we really need to be careful of here. It is a fairly novel legal theory, similar to these theories of equity that we discussed previously. It's not something I'm seeing popping up in a ton of states, but it's popping up in a couple. And given the restrictions around cannabis law, I think it's likely to see that we're going to see a continuing increase in these.
And I'll just quickly dovetail onto that. When you look at issues associated with the Americans with Disabilities Act, Chad's hit it right on the head, that the issue has to do with the underlying condition. And I know we're going to talk about this a little more later, but one thing to keep in mind is that you're looking at whether a person is impaired in life-limiting activity.
Yes.
And so pair that up sometimes, or think about what that means from an employer standpoint in terms of defining your essential job functions. And so that's what ties into what may or may not constitute a reasonable accommodation. And so I'm thinking of a circumstance where perhaps an essential job function would be driving or operating heavy machinery. And I know there's a lot of exemptions in and around that stuff anyway, but if you think about what kinds of definitions you want to include in those essential functions, and again, we're going to talk about that a little more. I just wanted to mention that because I think that that's where it's all going to mesh up for employers, right? That's where it's going to become sticky and difficult for them going forward on this.
And Lisa, you have presented us with an excellent segue into the drug testing portion. And in fact, we're going to talk about some of those safety sensitive positions right now, because that is a massive issue. One of the, if not the biggest question we got when doing some of the marketing for this presentation was, can I drug test? What are my abilities to drug test? What limitations, if any, do I have? And it's not as clear cut as you might think, but it's also not as complicated as you might fear. So I have here a 4-point bullet point checklist. This is the general procedure and processes that you are going to go through. So number one, your drug testing is either going to come from your internal policies and procedures or some type of third-party contract or obligation, be this a membership agreement, auditing requirements from a vendor, or maybe, insurance requirements following a workplace accident, right? So step one, determine the source or the authority of your obligation to drug test. If you're deriving it from your internal policies and procedures, you will likely have greater leeway than you will with a third-party contract. Not to say there's no leeway there, but it's a little bit less wiggle room. Number two, determine the classes of individuals to be drug tested. Now, going to what Lisa was saying here, certain types of individuals are okay to be drug tested in a very, very broad basis. So say I own a auto mechanic shop, right? It would not make sense for me to allow the auto mechanics to use medical cannabis because those individuals are what Lisa referred to in what we might call as a safety sensitive position. I think as a general rule of thumb, and we'll talk about this during the employment policy section in a little bit greater detail, but I think that as a general rule, it makes sense to not permit safety-sensitive position employees, as well as those covered by applicable regulations, such as those subject to Department of Transportation regulations. I think it makes sense to prohibit those employees from using medical cannabis. Now, that's not to say you can't create differentiating factors here. For instance, let's go, say you own this auto mechanic or this auto body shop. While it may not make sense to allow the mechanics to use THC, and therefore when you drug test them, they might be eligible for THC drug test, you may not want to drug test your front desk clerks for THC. It may not make sense for them. Again, it is okay to create these differentiations in employment roles, but going back to what Lisa was talking about a little bit earlier, you have to treat these employees who are similarly situated the same. So if you're not drug testing your front desk employees, for instance, you have to treat them all in a similar fashion. You can't drug test all of them for THC. Similarly, if you are drug testing your mechanics, you have to drug test all of them for the THC compound. And going off of this, there's an argument to be made that certain individuals have a higher tolerance for THC, might be more experienced medical marijuana users. Given the fluctuating nature of state law and the potential liability that could be incurred by you as an employer should something go awry, I think it makes sense to just strictly prohibit in your policies certain employees from using medical marijuana, notwithstanding the fact that they might be an experienced user or it might be effective for whatever their ailment is. We'll talk about this a little later as well, but it may make sense to do a lateral job transfer for that individual. And as we talked about in the various state regimes slide, you will likely be protected in employer-friendly states in doing so to transfer someone laterally to another job where it's not safety sensitive and they can use medical cannabis. Step 3, you want to determine the triggering event. And this is simply what's causing you to drug test. Is it part and parcel of your onboarding procedure? Is it an insurance obligation following an accident? That's all that is. Number 4, review the drug screening requirements. Specifically, are you required to test for tetrahydrocannabinol, i.e. THC? Now, zooming back out, how does this all fit within the context of your internal policies and procedures versus a third-party contract? Well, you have discretion in terms of the internal aspect to set these in the manner and method that you want. You can determine what classes of individuals, you can determine the triggering events, and you can determine what you exactly are drug screening for. Again, the big pitfall here, though, going back to those theories of equity, your actions need to match your words. You cannot contravene your internal policies and procedures whatsoever in any fashion. And if you want to change them, hand somebody a sheet of paper, say, here's the addendum to that contract you signed, read it, review it, sign it, give it back. That is how you make sure that you can change your policies and procedures. But are you really just out of luck when it comes to third-party contracts? Not necessarily so. So third-party contracts will generally be broadly applicable without as much discretion as to the classes of individuals or the triggering events. However, when we get to requirement number 4 here, review the drug screening requirements, a lot of third-party contracts will give you the option of various service administrators or providers. Some of these administrators or providers, depending on the nature of the workplace accident or what happened, will not require a THC drug screen. So it's worth your time to consult legal counsel, HR, compliance, whomever, to look at these various contracts and determine whether a THC drug screen is necessarily required. Furthermore, don't underestimate your own negotiating power. Now, I'm not saying go to Allstate and say, hey, unless you allow our employees to use medical cannabis, we're not using you for insurance. But if you have a vendor who has a boilerplate drug testing policy required on a quarterly basis or something to that effect, and you go to them and say, look, we employ telemarketers, for instance, who are in non-safety sensitive positions as opposed to individuals in our warehouse who are safety sensitive. Is it okay if we have an exclusionary drug testing policy for those telemarketers? You might be surprised at what you're allowed to do and what people might be amenable to. Now, this also goes to say when it comes to the drug screens in general, this is specifically limited to THC tetrahydrocannabinol. You should absolutely still continue your drug testing policies and procedures with regards to other drugs such as opioids, barbiturates, stimulants, and benzodiazepines. Now, what are the steps to an effective drug testing policy? Well, I just laid out the 4 bullet points there for you. Great pathway to follow. Very, very critical that you analyze each of these individual steps within the context of your organization. But the other 2 big parts are consistency and awareness. So the consistency gets to what we were just mentioning, the similarly situated issue. All individuals of similar classes need to be treated the same, and this should be part and parcel of your policy. Because as Lisa was talking about, when you get into those discrimination claims at the state level, those arrive when you have a lack of consistency, and that can be in your drug testing policies as well. Number 2 here as well is awareness. Your employees absolutely need to be aware and up to date on what your drug testing policies are. Specifically, anytime there's a change in the policy or procedure, like I said, hand it to them, have them sign it, read it, hand it back. This should be part and parcel of your standard contract and onboarding procedure, and any amendments or addendums should be reviewed and signed off, initialed by employees as a separate amendment to that contract. Discharge. Now, unfortunately, there might come a time when you need to discharge an employee who's a medical marijuana user. How do you go about that? Well, we've already covered the implications of the ADA and the proper record keeping and substantiation procedures that are necessary to do something like that. But how does this work with drug testing? Well, you need to first determine your rights as an employer. This means going to the statutory language. In the case of a state like Ohio, for instance, you can drug test a medical marijuana user for THC and then fire them for THC, as long as that's in accordance with your policies and procedures, notwithstanding the fact that it's legal for them under state law. Contrast this with a state like Illinois. If you recall, we said that in Illinois, these types of users are effectively a form or type of protected class, right? And in fact, Illinois prohibits you from firing certain types of qualifying medical marijuana users on the basis of a THC positive drug test. There are, of course, certain exclusions for individuals like police or, again, individuals in safety sensitive positions, but really the statutory language is your starting point. And even if you can drug test someone for THC, like in the case of Illinois, you might not be able to fire them on that basis. And then you're finding yourself in a situation similar to the ADA, where the marijuana firing cannot be pretextual or ostensibly the reason for another issue that you're actually firing for. Getting this case here, Cotto v. Ardagh Glass Packaging, Inc. This is just kind of a foundational employment marijuana law case out of New Jersey, which basically holds that in the absence of a prevailing state provision, you do in fact have the right to drug test and take an adverse employment action on an employee for medical cannabis usage. Now we get to talk about CBD a little bit. CBD stands for cannabidiol. It is one of hundreds of cannabinoids in the cannabis plant. How many times can you say cannabis in one phrase? So what exactly is CBD? I just mentioned it's one of hundreds of cannabinoids. And these are specific chemical compounds unique to the cannabis plant that interact in a lock and key mechanism with the endocannabinoid system in the human body. Fun little fact is that the endocannabinoid system in the human body only interacts with these chemicals, and there's no other chemical known to man, nature, or otherwise which interacts with the endocannabinoid system but those found in the cannabis plant. So it's a very human-centric drug in that respect. But critically, what makes CBD different from THC? Going to go back, there are three things you take away. This is one of them. CBD differs from THC, tetrahydrocannabinol, in two particular ways. Number one, CBD does not produce psychoactive effects. It instead produces ameliorative effects, potentially neuroregenerative, depending on the studies you look at, but most notably anti-inflammatory. So what that means is the colloquial high associated with the cannabis plant will not be produced in an individual who is only taking CBD. I'm sure your minds are swirling with the implications for safety-sensitive positions and such, and we'll get to that shortly. But the other major consideration is that following passage of the 2018 Farm Bill in, you guessed it, 2018, CBD is now federally legal, so long it is derived from hemp containing 0.3% or less THC, produced in accordance with the federally approved plan by the USDA, and in pursuant to state regulations and rules. So the big takeaways there are CBD is federally legal and it will not produce psychoactive effects like cannabis is typically associated with. What does this mean for your employment policies, insurance, and drug testing? Well, we talked a lot about how certain employees should not be permitted to use THC, particularly those in safety-sensitive positions or who are covered by prohibitory federal regulations like Department of Transportation regulations. That's not the case with CBD. CBD is federally legal. It will not make someone a little loopy on the job potentially, and there are great studies that show that it does have anti-inflammatory properties. So in many respects, CBD can almost be kind of analoged to a Tylenol or an Advil or an Aleve. Now, of course, they're different. You do want to treat them different, but when it comes to your marijuana employment policy, it is absolutely worth differentiating CBD from THC. And this is just my personal opinion. I don't think there's necessarily a good reason to keep employees from CBD, even if they're in a safety-sensitive position. Following up on that, insurance and drug testing. The types of tests that you're concerned about here, whether it's drug testing or it's an insurance company following a workplace accident, they test for tetrahydrocannabinol, THC. They do not test for cannabidiol, CBD. So even if you're concerned about someone in a safety-sensitive position getting in a workplace accident and then popping up positive for marijuana and invoking a whole host of parade of evils, perhaps your employment policy prohibited these types of individuals from using marijuana, and now even though they only were using CBD, they pop for marijuana on drug test, that is not necessarily a concern. Insurance and drug testing are primarily concerned only with THC when it comes to testing for marijuana. So insofar as an individual is using CBD, they will not get in trouble. Now, THC is fat soluble, meaning it is stored in the body and accumulates for a longer period of time, and CBD that is currently lawful does have 0.3% or less THC. It is possible, I would say, exceedingly rare, and I have never heard of it happening, but there is the very, very slight possibility that a certain accumulation of the CBD could lead to a certain accumulation of THC, which might rise to a certain level on a drug test. Again, this is exceedingly rare. I do not think it would happen, but I have seen this as an extremely common concern amongst employers with drug testing and CBD in particular, so I want to mention it. Another concern some employers have is, what if there's an excessive amount of THC in the CBD? Well, if that ends up happening, your employee will test positive, but I would also say your employee has quite the incredible lawsuit against whoever sold them that CBD in that situation if it does contain THC above that level. Again, it is federally regulated, federally legal, and does not produce psychoactive effects. CBD is generally permissible in employment situations.
You could almost do a whole separate webinar on what kind of requirements are in and around the advertisements and representations about what are in CBD products. So
stay tuned for an upcoming consumer protection webinar on that very issue. That sounds great.
Yeah, we may have identified the next in our series.
Absolutely. So let's get
So
into the
you want
employment
me
policies.
to talk a little bit about this?
That'd
or
be
do you wanna-
fantastic,
Okay,
please.
so on the employment policies, and this is kind of dovetailing off of what Chad was just talking about with considerations in and around all of this, really. It ties into everything. It's tied into the case law, it's tied into the testing, it's tied into literally, I feel like every piece of what we've talked about today. And so, you know, in terms of looking at and developing policies, there are some best practices that you should think of as we all know that people will be continuing to expand into this space. This will continuing to be facing employers, and it'll be developing. And so one of the best things that you can do as an employer right now is to really implement clear employment policies that take into consideration not only the law, but also what you want for your employees, particularly when we are in a time where many industries are struggling to find employees. And so I think
And Lisa, I'm so sorry to interrupt, but I actually saw this yesterday.
Yeah.
A lot of businesses, in order to attract talent, are no longer drug testing for that exact same reason.
Right. I saw the same thing, and you kind of alluded to that earlier with the Amazon. And so I think that it's just so apt that we're talking about this now, because it's hot. It's what employers are facing, and you're absolutely right that you're really having to look back at these policies, right? And so, you know, one key thing you can do is be very clear in what your policy is, right? No room for interpretation, no ambiguity. You know, if we're going to have drug testing, for instance, as Chad pointed out, to the safety sensitive positions, we need to define what those are and who those are. And if we're not going to require it for a classification of employees such as your front desk clerk, you're going to want to define those, right? So it goes back to even looking back to the ADA considerations about defining your essential job functions, having with connection of each of your titles, having those functions described out. So there's a nexus, there's an explanation as to what the thinking is, and that you don't have employees inherently questioning, well, why would somebody who's working under the hood of an automobile be subject to a different standard? So the clarity, I think, helps that just protect employers, but also to let the employees not feel like they're being treated in some kind of inequitable way that doesn't make sense. It should be specific. And so this is going back to what Chad's talking about what does a positive test result mean, right? So there's different kinds of tests, and I'm sure you could do a whole another presentation on what they look for, but Chad provided this great explanation about how if somebody's just using a CBD product, such as an oil or a lotion or some kind of things, which we all see as being very popular out, it's not very likely that they're going to test positive for the THC. And I think even having some explanation within your employment policies about that might be warranted, because I know that many people, just many lay people in the general public, whether you're an attorney or not, just do not understand the scientific difference that Chad just explained between these two products. So maybe even some kind of clarity for your employees to understand your use of this hair product is not going to necessarily, you know, render your test positive. Chad talked about interaction with insurance and drug testing. And I know for many of my clients who I deal with, particularly in like the automobile space, for example, do have a lot of, they might have a lot of employees, and they only have a small segment of them that are in those safety sensitive positions. But depending on the kind of insurance they have, if there's some kind of accident, whether it be on site or like maybe even with a driver being off site of the employer, but in the course and scope of his or her employment, there might be insurance drug testing procedures. And then, you know, make sure you read your policies, make sure you understand what those are and what the drug testing procedures are. Make sure that those drug testing procedures are no more restrictive than what's in your own employee policies.
Absolutely.
So that could be a time bomb. Job duties, I talked a little bit about this, and this is important not only for the ADA requirement. But for all of these factors that we're talking about, if we're talking about defining what job duties are, and here's a big landmine for employers is they'll have a job description, and either it's not updated or it's not accurate to reflect what the employee is actually doing. So those job descriptions and the duties really need to not only be updated because things are fluid and they change over time, and maybe the course of the landscape of the employees do, but those duties actually need to reflect what those employees are doing. So if I wrote a job description for an associate attorney at our office that indicated they spent 80% of their time driving, doing different skills that were safety sensitive, when that is not true, that does not reflect, that does not help to keep your policies clear. It does not help to protect you in the context of potential ADA liability. And so that would be another tip I would talk about with respect to employment policies. And then just Chad, if you want to quickly wrap up with like this differentiation between the types of policies that apply to THC versus other of these substances.
Absolutely, Lisa, you did a fantastic job highlighting the big considerations here. Really, your employment policy, as Lisa alluded to, this is what is going to be looked at by your employees, by the regulators, by the insurance companies. This is the touch point. And, it only needs to be a couple paragraphs, a little bit of a plug. McMurray and Schuster does marijuana, cannabis employment policies for a flat fee. But to that point, this is the entire encapsulation of your business's cannabis policy. It needs to very explicitly say who, what, where, when, why, under what circumstances someone is able to use cannabis, medical cannabis, if at all, what the implications of it are, who will be drug tested, and as Lisa said, why those individuals are getting drug tested, whereas others are not. Now, getting into the CBD versus THC issue, there's a couple ways you could go about this. One way that I think is the wrong way, and I'm going to show you why I think it's the wrong way. The wrong way, I think, is to say we will or will not allow medical cannabis, but we will allow CBD. Why do I think that's the wrong way? I think it's the wrong way because you need to make the distinction between CBD and THC specifically. Say you have an employment policy that prohibits cannabis, okay, but does not specifically differentiate CBD and THC, okay? Now, say you have an employee who uses CBD. It's federally legal. It does not produce psychoactive effects. I mean, technically, as an employer, you could prohibit it just as you could really prohibit anything in certain scenarios if you really want to. But say you have a flat no cannabis policy, but someone is using CBD. If you had a particularly unscrupulous, clever employee, they might be able to say, well, you say no cannabis, but you're allowing CBD, which is derived from cannabis. So even though it says no cannabis, I can use THC, which is derived from cannabis, which is, again, a very clever reading of what your policy might actually mean. But under those equitable theories that we were talking about, particularly promissory estoppel or detrimental reliance, that might be enough to get them past the motion to dismiss stage and incur you significant liabilities and unnecessary expenditures of time and resources. So really, you want to create differentiations between CBD and THC. Again, CBD is derived from hemp, which is a marijuana plant material containing 0.3% or less THC. So creating that distinction, in addition to the clarity and specificity that Lisa was talking about with these other items, is really key. And remember, if it's not in your marijuana employment policy, it's not in your business. It has to be in here.
This is why understanding the science is so critical.
Absolutely.
Chad. It's so critical.
And I'll put in another plug for qualified and competent legal counsel there. This is one of the very unique areas of the law where the science is evolving just as quickly as the jurisprudence, and having counsel who is up to date and aware on both is not only essential but rare. So really retaining qualified counsel is critical here.
Really critical. And then just kind of, I know we've gone over time a little bit, but it's just such an interesting topic and there's so much around it, to try to keep it into a half an hour, but just kind of tie up these things that we've talked about today. You know, why work with medical marijuana users? There's tons of reason. You know, a key that we just talked about that we just talked about just came out in the news is, you know, employers backing away, walking these policies back due to the lack of available employees. I think Chad could fully attest that a lot of our medical marijuana users who are employees have more creativity, they have more clarity, they have less stress, less anxiety, you know, work-related anxiety, brain drain, whatever type of term you want to use, but they don't fit, I think, the typical stereotype that we thought about. I think that they are people who are good workers, valuable workers, and generally experience less of all of these stressors, right? We talked about employment policy considerations and job modifications, considering how to define your the job descriptions that fit to being true and accurate. And with that, Chad, you have any last words you want to add about working with employees who are our users?
Yeah, you know, just a couple quick things. Piggybacking, and again, I know we're low on time, but very briefly, piggybacking on the fact that a lot of employers are not really drug testing for THC anymore. The Department of Defense, for instance, recently announced will no longer be testing drone operators for cannabis. So I'm not sure if you know much about drone operators, but you sit in a 4x4 room using a facsimile joystick. And so one of the heavy recruitment pools for drone operators are retired professional video gamers, interestingly enough. So a lot of these individuals have a history of cannabis use that they would previously be prohibited from working with the government with. So in order to find qualified individuals, the U.S. government and other branches of the military, in fact, outside of just the Army, are no longer screening for THC. And one of the big reasons, and this might be something that touches a lot of our participants on kind of the personal level, is medical marijuana is an exceptional substitute for opioids. Particularly in the Midwest, we are suffering a very drastic opioid epidemic that's affecting many individuals, and medical marijuana can be a viable substitute for many of those individuals. And particularly for those who are already using opioids, you might already be taking certain considerations into account. For instance, they aren't in safety sensitive positions, given that they might be under the influence of these drugs. It might be an easy transition for you as an employer and for those employees to transition over to medical cannabis.
Yeah, it's a great point. It's a great point. Well, this has been so wonderful and informative, and I feel like I could sit here with Chad and talk for another hour about all of these things. And we just want to say thank you so much for joining us today. I want to say thank you to Chad for joining in with me on this discussion today, and would just invite you, as I mentioned, if you have questions, please put them in the chat. We'd be happy to follow up with you. And if ever you have other questions or need any assistance in this space, feel free to reach out to us.
And thank you to Lisa for your absolutely unparalleled knowledge of employment law. It's an absolute thrill to be here and present with you. And thank you to all of our attendees. Hope you have a wonderful rest of your day.
Thank you.